on this side. That's kind of good. Before we get started with our very special guest, I did want to make a brief announcement to those folks who have registered for Healthy You, except if I forgot yours. You will find your name over here with your points book, so you can pick that up. If you don't see yours, just let me know and I'll go get extras kind of at the end. And if you don't have one of these, you have the opportunity, of course, to still register. I know there are folks who have not registered, and you totally should, because you can get days off or dollars off by coming to Lunch and Learns and other fun wellness activities. So please, there are sign-up sheets and logs, and please take advantage of them. Thank you all for coming. Another healthy lunch provided by Wellness. You'll notice that it is June 29th, so of course we know what that means. So pizza is very cheap, and Papa John's gives us a very nice discount, so enjoy. And of course, starting July 1, when the points kick in, I'm sure everyone will totally change their diet. It'll be all salads and lean protein and all that kind of stuff. So we do have two very special guests here today, and someone asked me, is like, how is this wellness related? But actually, this has been a topic that people have been asking me for probably for at least 18 months or so. Every once in a while, someone says, hey, can you bring in some lawyers? Like, we really want to kind of know about how to do this estate planning thing. So we do think about this as wellness, if not personal wellness, but then financial wellness. So without further ado, our two esteemed lawyers, I don't know why they're looking like that. If you guys want to come up, and we are podcasting here, so you guys will see Jerome back there. All of our Lunch and Learns are going to be podcasted from now on, so you can, if you missed anything, you can always watch them over and over and over again. So if you guys want to come on up.
Hey, my name is Amy Smith Boyer, and I'm a graduate of Mercer University. I graduated here in 1994, and then I went up the road to the University of Georgia Law School to get my law degree. And since 1997, I've been practicing law in Forsyth, Georgia, just up the road. Molly and I both practice in Forsyth, and we both are since we're in a small town, we're sort of like family physicians. We basically do a little bit of everything. But what I specialize in is estate planning and probate, real estate. I do a fair amount of commercial litigation, and a few other things. But I don't handle any divorce or criminal law, and I think Molly and I share that sentiment. But one interesting thing about probate and estate planning is I say that I don't handle divorce, but unfortunately, sometimes when people don't do proper planning, or even when they do proper planning, when someone passes, it can be very nasty. So whatever you can do as a family to help your family out, which includes planning, it's a good idea, because that's a critical component to make a smooth transition from one generation to the next. But that's a little bit about me. I'll let Molly introduce herself.
I'm Molly Hudson Watson. I grew up here in Macon, and decided for one reason or another to go off to New England to go to college. So I got my degree at Middlebury in Middlebury, Vermont, and then went off to Alaska for a while, and eventually decided to come back to Macon and go to law school. That was always kind of the plan, but I had to get some stuff out of my system. So anyway, I came back here and graduated in '98. I've been with the same firm since '97. That's my firm up in Forsyth, Hagood, Lynch, Harris, Melton, and Watson. And basically, like Amy said, we're in a small town, so you wouldn't believe what walks in the door. I mean, we get everything, but we're general civil practice. We can't help you if you killed somebody, but we can send you to somebody who can. And we probably can't help you if you're unhappy with your spouse, but we can send you to somebody that can. Amy and I do real similar work. We're kind of like members of the same firm. We have to work together and have enjoyed doing so for years. What else do I need to say? Basically, Amy went into a little bit of an intro about why this area is so important, and like her, I could say I don't do divorces, but I've been involved in some pretty sticky probates, because when somebody passes away, sometimes even the best prepared families are going to deal with real difficult issues. So anyway, that's who I am, and I'll let Amy get started with the first topic, and I'll follow her with the second.
One thing I did neglect to mention is my husband, Ken Boyer, also works here. Many of you know him. And my law firm name is Vaughn Wright & Boyer in Forsyth, and I've been there for 14 years. And between the two of us, we can tell war stories for hours. So our main problem is to try to keep it, informational and stay on task, because we can talk for hours about what happens when you don't do probate correctly. First of all, I want to commend y'all for coming, because this is not an easy topic for most of us to deal with. It's better to ignore it and stick your head in the sand than to deal with it. And so I do commend y'all for coming. And to lighten it up just a little bit, I do have one little joke I'd like to read. It says, you'll have to forgive it, it's slightly inappropriate, not much. Brothers Mike and Cernus O'Malley were the two richest men in town, and complete shits, both of them. They swindled the church out of its property, foreclosed on the orphanage, and cheated windows out of their last mite. And that was just for starters. Finally, Seamus up and dies, and Mike pays a visit to the priest. Father, he says, my good name will be upheld in this town. You'll be given the eulogy for my brother, and in that eulogy you're going to say that Seamus O'Malley was truly a saint. I won't do such a thing. 'Twould be a lie. I know you will, says Mike. I hold the mortgage on the parish school, and if you don't say those words, I'll foreclose. The priest is over a barrel, and if I pledge to say those words, then you'll sign the note over free and clear? Done, cackles Mike, and he signs over the note. Next morning at the funeral, the priest begins the eulogy. Seamus O'Malley was a mean-spirited, spiteful, lying, cheating, arrogant, and hateful excuse for a human being. But compared to his brother Mike, Seamus O'Malley was truly a saint. The other one I'll mention just briefly. The relatives of the family's rich dowager gathered for the reading of her will after a long-awaited death. Being of sound mind, said the lawyer, as he was reading her will, I spent every last cent before I died. So that's actually a good example of someone who did proper planning. You may not agree with her method of planning, but she did spend some time planning. And that is, it's very important to do that. And estate planning includes a lot of different things. It includes a will, it includes healthcare powers of attorney, it includes financial powers of attorney. It also includes other intangible things like telling your loved ones where you want to be buried, down to the casket details, what songs you want, but for the purposes of today's discussion, we're mainly going to be talking about the documents, the wills, the healthcare powers of attorney, financial powers of attorney, and things like that. And one thing that we frequently get asked is what exactly is probate? And probate is what you do when someone passes and they have assets that have to be transferred to someone else. And there are two ways that you can probate an estate. The first is if you have a will, which is your written document expressing your wishes, then you enter that document into the probate court through a process. It's fairly inexpensive and fairly quick, and the court looks at the will and decides whether it's a valid will and whether or not it should be accepted by the court. If the will is accepted by the court, then your personal representative, your executor, their sole job is just to follow your wishes. So that's why it's very important to have a will, because you can tell what you want done and how it's done. If you don't have a will, then you're left with, in essence, the state telling your loved ones where your assets go and maybe even who gets care of your children. And so if you have a will, you probate the will. If you don't have a will, it's called administering an estate. And that's when the state of Georgia comes in and says, X, Y, and Z happens because those are your heirs, and this is who's going to inherit your assets. So that's really just a brief overview of probate. Probate is just taking your will, taking it to court, having it proven, and then letting your executor do what the will says. And with that, I'm going to let Molly talk about what exactly a will is.
Okay. I think everybody pretty much knows what a will is. I mean, it's a document, a legal document. It's got to be witnessed by two people. You have to be over the age of 14 and of sound mind and all that. So I won't spend a lot of time talking about what it is, but I will try to answer the question that so many of my really bright clients ask me, which is, do I really need a will? If I die, doesn't everything go to my husband or my wife or whatever? And the answer to that question is almost always yes, you need a will. There are certainly some limited circumstances under which somebody might not need a will. If we're talking about maybe an elderly person who's already in a home, has no assets, has maybe only Social Security income, then maybe they don't need a will. But if you own anything, you need a will. If you have minor children, you need a will. And the reasons for that, Amy kind of touched on. If you pass away without a will, a lot of people assume that all your assets will automatically go to your spouse. Well, it doesn't work that way. Georgia law dictates that your spouse is entitled to no less than 1/3, but the other 2/3 would be distributed among any surviving children. So that's pretty important. A lot of people don't really think about that. You might have a child that, you might have minor children, or you might have a child that you didn't want to have the responsibility of taking under your will or under your estate. The other main thing that Amy touched on is if you have minor children, your will is how you dictate who will care for your children. And, there are sort of two aspects of that decision to make. The minor children will need a guardian, and that's the person that basically stands in your shoes as the parent who decides on the schooling and all that. But there's also the conservator, because you need somebody that will be in charge of handling your assets for the benefit of that minor child until that child becomes a certain age and then could have those assets for himself or herself. So it's always a really difficult decision for people to make. It's not always obvious who the guardian and or conservator should be for minor children, but it's something you really need to think about, because if you don't have a will, somebody else will make that decision for you, and it might not end up the way you would want it to be. Let me think what else we need to say here. Another question I get a lot, and these are great questions, and I'm always happy to answer them, but a lot of times we have people coming in to us to see us who may not be from Georgia, and they've been told somewhere, or they've read it on the internet or seen it on some show, that you don't need a will because you want to avoid probate. You should have a trust or something to this effect. And that might be true somewhere else. But in Georgia, as Amy was sort of touching on a little bit earlier, probate is so easy and so inexpensive compared to some places, like, for example, Florida, where you want to avoid probate, from what I've been told. I'm not licensed to practice in Florida, but a lot of our clients who have come from Florida or California or North Carolina or New York have been told, stay out of probate, you need to take care of your estate plan with a trust. And in Georgia, that's really just not the case. As far as having a will and going through probate, having a will prepared by an attorney, and I'm not just trying to get us business, but it's really best in Georgia to have an attorney do it for you, is really not that expensive. And going through probate with a will is not that expensive, especially when you compare it to the alternative. If you don't have a will and your heirs have to go through an administration, you will probably end up paying more in legal fees and court costs than if you'd paid a lawyer to do your will. So it's really that simple, and I feel pretty confident saying that with most attorneys, that's the way it would be. As far as trusts go, and if y'all have questions about that, maybe when we get to the discussion period, we can talk a little bit more about it. I'll just say that in Georgia, for most people, there is no need for you to have a trust. If you are individually worth more than $5 million, or as a couple 10, you might need a trust for estate tax planning purposes. Right now, that's the case. If you have a child with special needs, you might need to consider a trust. But these are very special circumstances, and we counsel every client individually when we're dealing with circumstances like that. Let me see. Okay. As far as having a will, and just I want to touch on there's so many things you can do with a will. And believe me, Amy and I have seen some pretty unusual things done in wills. We've seen pet wills. Have you seen pet wills?
Actually, the new Georgia law now actually allows trust for pets. So,
Yes.
So if you want a trust for your pet that survives you, you can do that now.
That you can do it, and we've done it. And, it's legal and binding, and you can do that. I don't, when I talk about trusts being a very specific thing that a lot of people in Georgia just don't really have a need for, they're also expensive. A trust is an entity that comes to life, and it has to file a tax return and all this kind of stuff, so it's a little bit of a burden. That's a trust created in life for those kinds of circumstances. We also have what we refer to as testamentary trusts that are pretty simple. And Amy and I both touched on it a little bit. Say you have minor children. You want your will to have in it a testamentary trust for the minor children. And basically, you're setting up your will so that your assets will be held in trust for this minor child until he or she becomes 18, 25, 30, whatever. And we can craft these things so that they suit your circumstances and the personalities of the people involved, or the needs, I should say, of the people involved. Also, I mentioned special needs as a reason to have an inter vivos or a trust created in life, but if you have a child with special needs, and I don't mean a minor child, I mean even an adult child, it's very important that your will be crafted specifically with that child's needs in mind. That child may need to qualify for state benefits, and if your will is not crafted the right way, your will, or your lack of a will even more so, could disqualify that adult child with special needs from getting assistance from the state. So that's really important, and we're working with people with those kind of issues more and more. That's really sort of wills in a nutshell. I'm sure y'all are going to have a lot of questions about that, but I'm going to let Amy pick up with the healthcare directive, and then we'll talk a little about financial powers of attorney, and then we can come back to wills and stuff in the discussion session.
I would just add one thing. With regard to wills, if you're thinking about preparing a will, the most important thing, obviously, you need to decide where you want your assets to go. And once you've made the decision where you want your assets to go, you also need to consider what happens if your chosen beneficiary doesn't survive you. So if you're a husband and wife and you want to leave everything to your spouse and you're in a car wreck, well, then you also need to have the second step of what happens if you die in the car together at the same time. And you can go on and on down further and further. So you need to think very carefully. Don't just stop at the first step. You need to think about who's going to get it after, if something happens to both of us at the same time. The second thing that you need to think very carefully about is who is going to be your personal representative. That is also called your executor or your executrix. The personal representative is someone who you would trust to handle your financial affairs. They would be in charge of collecting all of the assets of your estate, basically creating an inventory of what you had. And then the second thing that they would have to do is find out who all of your creditors are. Because the first thing you have to do as an executor is you have to pay the debts. You can't, unfortunately, just distribute the stuff out to the people. You have to pay the debts first, and then if there's anything left, then you pay according to the wishes of the will. So that's very important to pick who your executor is. And Molly was talking about trust as well, and we're throwing a lot of concepts at you, but conservator and guardians of the person and property. I think we used to just call them guardians, but now they call them conservators. But these are the people who would look after the property of your children. If your children are minors, they can't tend to their own affairs, so you're going to think about who do I trust with my child's money. This may not be a family member. I mean, it may be, a friend. And then you need to figure out who would I trust the child's care to. The husband and wife are killed in a car wreck together. You need to think of who a family member would be that you would trust to actually have possession and care for your children in the same manner that you would want them cared for. So that's very important, and it's a hard decision. I know a lot of clients that I have. I've been practicing law for 14 years, and I have wills in my file that are 12 years old. Every time I see the client, they say, I'm going to come sign it, I'm going to come sign it. And they never do because they're struggling with the issue of which family member to select as the caretaker of my child, or who do I trust enough to handle my affairs. So you need to spend a significant amount of time trying to figure out who you think can do a good job and who you trust enough to care for your money, but more especially your children. But anyway, that's a little bit about wills, and I know y'all have questions about that. But the other document that I'm going to talk about is a healthcare power of attorney. And what that is, y'all probably have heard the word living will before, and I think most people are more familiar with the term living will. back several years ago, the state of Georgia, in essence, did away with living wills. That doesn't mean that if you have one, it's no longer effective. But what the state of Georgia has done now is created this new document called a healthcare power of attorney. And it's a statutory form, and it has components of a living will and a power of attorney combined. And so the document does two things at one time. The first thing it does is it names an agent to make healthcare decisions for you in the event that you can't speak for yourself. If you're in a coma, stroke, you just can't communicate what your wishes are, you can designate someone to be your agent to make your healthcare decisions for you. And the general power of attorney is as broad as it can be. Basically, any healthcare decision that you could make about your healthcare decisions, you can designate this person to make these decisions for you. That includes withholding fluids, food, stopping CPR, pulling you off the ventilator. Any decision you could make, you can designate that decision to an agent to make for you. The second part of a healthcare power of attorney is the living will component. If your agent is unable to make these decisions for you, say you're in a car wreck together, the healthcare power of attorney document now includes a living will component so that if that document is available, the doctors can look at that document and say, oh, well, this person did not want to be on a ventilator. So the document itself can speak and tell doctors what you do or do not want. But the better thing is to have the agent there who can tell the doctor, Sally wanted to be fed with water, but she didn't want food, or Sally wanted vice versa, or Sally didn't want anything. She just wanted her natural death to occur. So the best thing to do is you pick an agent, and again, it needs to be someone who knows your wishes. You need to communicate with them and tell them what you want done in the event that something happens. And then you would select him or her as your agent, and you can have a backup agent. If that person can't do it, you can pick up another person and they can be your agent as well. And basically, there are three choices in that document. And you can tailor the document a little bit. It has blanks where you can add personal preferences. But basically, the first one is do everything humanly possible to keep me alive no matter the cost. And believe it or not, I had a World War II veteran who wanted that option. He was 88 years old, and he checked that one. And I was sitting there looking at his daughter going, why does he want a healthcare power of attorney if he wants you to do everything possible to keep him alive? Because that's generally what they do anyway. But the second option is basically to let my natural death occur, and then they give you pain meds and stuff like that. But at that point, they'll withhold ventilators and fluid and foods and stuff like that. And then the middle ground choice that you have is basically you just pick and choose what type of care you want. If you have a hang-up about dying without a ventilator, you can say specifically, I want a ventilator, but don't give me food and fluid. So there's some middle ground in there. And those documents are effective. If you name your husband as your agent and you get a divorce, then it's revoked, okay? So you don't have to worry about that. But if you do name your spouse as an agent and you are going through a divorce, it'd probably be a good idea to tear it up before the divorce becomes final. And the other thing that revokes them is marriage. Sometimes marriage will revoke them as well if you get married after you make the power of attorney. Those documents are very similar to wills in that they have to be witnessed by two people. And if you're in a healthcare facility at the time that those documents are signed, you have to have an additional witness. So they're a little bit peculiar in that regard. So that's a little bit about healthcare powers of attorney.
Okay. I'll talk a little bit about financial powers of attorney, but I imagine most of y'all probably have a pretty decent understanding of what that is. We call it your business power of attorney, your general power of attorney, but it has nothing to do with healthcare. This is the instrument that enables you to appoint somebody, your attorney in fact, to do your business for you. And as y'all may, if you've ever dealt with a big lending institution or, any big company, they don't want to talk to anybody who's not on the account unless they've got a full executed power of attorney. That having been said, and the one that I generally prepare is about 8 pages long, and it will enable your attorney in fact to do just about anything you could ever need to have done as far as dealing with stocks and bonds and banks and property, everything. But that having been said, powers of attorney, I would say it's been my experience, are scrutinized a lot more than they used to be. So For example, I had a lady come in, she was a regular client, she had an older power of attorney, and there was nothing wrong with it. I looked at it, we had not prepared it, but she was irate because she'd been to her bank where she'd banked forever, and all of a sudden they wouldn't accept it. She was attorney-in-fact for her disabled sister, and suddenly she couldn't write a check to pay for her sister's care because the bank said, this thing's too old. And it was 4 years old.
But if the person that gave you the power of attorney is no longer competent or no longer has capacity to sign a new power of attorney, you end up in a huge problem.
Right.
But banks and lending institutions are becoming much more stringent with powers of attorney. And there's a great potential there for fraud. I mean,
Right.
you understand why they do that.
Yeah.
But it's a huge problem when you rely on this document and the bank just says, oh, well, that document's no good because it's 4 years old. Well, if the person's been incapacitated for more than 4 years, I mean, that's the best you're going to get.
That was our case, too. She did not have the mental capacity to sign a new power of attorney, so I told her to go to another bank, but, you know, I'm not sure how that worked out. What would then have to happen, and we can answer questions about this maybe later, if you've got a power of attorney that is no longer accepted, and I guess the main reason I want to tell that story is because a lot of you may already have powers of attorney, but I would recommend, you know, maybe updating those things every couple years, the same way you'd pull out your will and look at that every year or two, because circumstances change, you know, situations change, and you just want to review those things and make sure everything's up to date, because I know I'm starting to do this just like my dad. I say, well, yeah, I did that just the other day. Well, it turns out it was about 10 years ago. Where did that time go? But, you know, I finally got my parents, and my dad's an attorney, to redo his will because I'm 40 years old and I was going to have to go live with Aunt Christy, you know. So that I wouldn't have really had to, but that's how old his will was, and he knows better. But we got all that taken care of. But anyway, that financial power of attorney and the advance directive, Amy and I agree that if somebody comes to me and they say, well, I really just need a will, what I usually say is, well, I'm going to charge you the same thing, but I'm going to do an advance directive for health care and a financial power of attorney because you need it. And just do it all at the same time. So, you know, even though you can run into trouble with financial powers of attorney if you're dealing with a big bank, it's good to have one. It's very important to have one, and it's very important to have one that's up to date and very specific. The more specific a power of attorney is, the better, because we've certainly run into situations where somebody had a very simple little power of attorney and it didn't actually authorize the attorney-in-fact to do a specific thing for the person, and then it's not worth anything to you. The situation we had, and like Amy was talking about, where for whatever reason the power of attorney is no good anymore and we can't get a new one executed because the lady didn't have the mental capacity, well, then you've got to go to probate court and get appointed as a guardian, and that is tough. It's not impossible, and it's not something that should be looked at as something to avoid, because a lot of times it's inevitable. If you've got an aging parent or a sibling, you know, anybody who can't make decisions for themselves, you have to be appointed by the probate court as guardian and conservator if they own any property, and Judge Self will put you through it. I mean, he will make sure that you have dotted your I's and crossed your T's, and he's the best. I love Judge Self, and I call him when I have questions because he knows everything. But a guardianship is just a real burden, and if you don't have that power of attorney in place, that's your only option if you've got to deal with an aging parent or sister or whoever. So just keep that in mind. That simple power of attorney can save a lot of expense and hassle, and help you to avoid the guardianship process, even though that it could become inevitable, and it's not always a slow thing. But once you're appointed by a probate court as guardian and conservator, you then have to report back to the probate court every single year and provide inventories and accountings, and you know, somebody really looks at all that stuff to make sure that you're not taking advantage of your ward, which is a great thing, but it's also a burden.
And frequently, there are also bond requirements. In order to become a guardian, you have to post a bond. So that can be a very expensive process, and it can be very burdensome. But like she said, a simple power of attorney would in most cases, eliminate the need for that. Where you frequently see an issue with powers of attorney is if someone has a single person that lives alone and they're in a car wreck and they're in a coma for a couple of months. Well, no one is on their bank accounts, and so no one can pay their mortgage, no one can pay their bills, and if they had a loved one that they trusted enough, and again, you have to pick someone that you trust, I mean, you know, then the loved one could come in with the power of attorney and pay their bills. Without the power of attorney, the person sitting in the hospital, their house is going to be foreclosed on. I mean, it's a nightmare. And you say, oh, well, we'll just get a guardian appointed. Well, the guardianship process takes, at a minimum, I'd say 3 months at a minimum. And so in the meantime, all of these bills are piling up and all these late fees and charges. So you know, powers of attorney are very important, but just be careful who you select, because you don't want just, I mean, we do see situations where some children abuse powers of attorney with the parents.
Because it's powerful.
It is. It's a very powerful tool. So you need to be very careful and choose wisely when you do powers of attorney. The other thing I'll touch on briefly with regard to estate planning in general, right now, Molly talked about the $5 million number. The estate tax system right now, unless, like she said, unless you have more than $5 million in assets, when you die, you will pay no estate tax right now. Congress has enacted a law through 2012 extending the unified credit amount of $5 million until the end of 2012. That doesn't mean that they can't come back and change that, and they have in fact changed that. In 2010, the estate tax unlimited, the unified credit was unlimited. So if you died during the year 2010, if you were Bill Gates, you paid absolutely no estate tax. 2011, it's now $5 million. What it was before 2010, I think, was $3.5 million. Mm-hmm. If Congress doesn't take any action before 2012, the unified credit amount will become $1 million. And so that's going to hit a lot of people. If you own any land or if you have any stock accounts, you know, $1 million is not that much money anymore. And so if you do not have a will, or if you do have a will, I'd suggest you pay particular attention to see if Congress changes the unified credit amount, because $5 million, not that many people have an estate tax problem. $1 million, you're talking about tons of people who are going to have an estate tax problem. And at that point in time, you go from talking about a simple will to having a will with trust. You know, once you get into an estate tax problem, we strongly recommend trust, because there are lots of tools that you can use. You can do gifting right now also. I don't know if you're aware or not, but you can gift up to $13,000 to anybody without paying any gift tax. You do need to file returns, but you would not pay any gift tax. When you do make gifts like that, it does chip off of your unified credit. So if you wanted to make a gift to a child, you could do that, but you need to file a gift tax return. And just realize that if you've got a $5 million unified credit and you make $13,000 gifts, it chips off your unified credit every year. But there are tons of different tools that you can use, but the main thing is to remember that 2 years from now, it may go from 5 to 1, or they could change it. You know, I think a lot of the talking heads are saying that they're thinking that they'll go back to $3.5 million, but there's no guarantee, because you know, the government needs more money, and that's an easy hit. So that's that, but that's an important thing to remember.
About internet, should I mention that?
Sure.
One of the things I was going to mention when I was talking about wills, and Amy and I are not the types to toot our own horns, I guess you could say, but internet wills. I mean, I use the internet for a lot of things, but Amy and I both had to deal with our first legal business.com wills, and you know, you pay a small fee to get this document, and then something happens and we end up with this will, and sometimes it's okay, but the problem with these legal.com wills is they're not state specific. So you're dealing with a will that doesn't incorporate the powers that you need in Georgia to administer the estate, and that is a problem. It also, these wills don't incorporate certain other powers or relieve the executor from doing certain things. Like, if your will does not specifically relieve you from filing inventories and posting bond and all that kind of stuff, the court may require you to do it. In which case, that $35 will has cost you about 10 times what it would have cost you to just have an attorney draw up a will and end up probating that. So we've actually run into these wills that are more difficult to probate than it would be to administer the estate without the will. So just keep that in mind. I'm not dumping on the internet or anything, but we've actually run into some real problems with these internet wills not incorporating the right powers or not relieving the personal representative or executor from certain requirements that the probate court would require if the testator or the writer of the will had not specifically relieved the person from.
One of the things I see frequently also, and it's not just internet wills, Molly's not bashed on the internet, but in Georgia you can do your own will. There's no law that prohibits you from doing your own will. You just have to do it correctly. And the problem that I see most when people try to do things on their own is that they don't have it witnessed properly. In Georgia, when you sign the will, the people have to be in the room with you watching you sign the will. If they're off in another room, guess what? The will's no good. And they have to be able to answer certain questions later. Once you die and the will is offered to the probate court, these witnesses that you had, they have to be found. And they may have to answer certain questions unless you go through another step and have what's called a self-proving affidavit. But even then, occasionally, you may still have to have your witnesses and they have to be located. The other problem that people, when they do their own wills, is that they frequently, I had one person who didn't date the will. Well, guess what? If it's not dated, chances are pretty good the court's not going to accept it. One person went in and she very carefully wrote the will out, and she wrote all of her grandchildren's names out, and she thought, well, I'll go back later and I'll put down the amount of the gifts. Well, guess what? Once you make the will, you cannot make changes to it. If you change that will at all after it's executed, it's invalid, it's void. And if the probate court if it looks like something was scratched out and initialed and done at a different time, well, guess what? You don't have a will. And we see that a lot, because the will law is so peculiar that most people just, most documents don't have to be executed with the formality of a will, but wills are very peculiar creations because they change common law, and so courts strictly scrutinize them. The other problem with wills that we see, other than missing signatures and missing information filled in, is that people will have multiple wills laying around their house. And then the question becomes, well, why didn't they tear up the older will? Which will did they really want? And so it just becomes a nightmare. So if you have a will, just make sure you only have one, okay? Because if you have children, and let's say you wanted to disinherit a child 1 month, and so you write this will disinheriting them, and then the next month you come along and you say, oh, well, I like them again, I'll give them something the next month. Well, guess what? When you die, let's say the other sibling is sitting there looking at these two wills going, oh, well, this one I get everything, this one I have to share. Guess which will I'm going to probate? So, you need to think very carefully about these sort of things. But I think if y'all have any questions, we'll be glad to answer them if y'all got any.